the third one.
All right, shall we get started, everyone? I feel very enthusiastic. 3 tables as usual. If you want to join them, you could, but if not, up to you. All right. So the plan for today is that we're continuing with homicide where we left off last week. So there are 2 parts of homicide. One is murder, the other one is manslaughter. So last week we look at murder, this week we look at manslaughter. Just going to, I just came right on time. Now, I'm just going to write down again, in case, what are some of the most important topics, all right? So we started off sort of examinable stuff, with offenses against the person. Okay. Then we have sexual offenses. Then we have homicide. It's 2 parts to this. All right, so one is murder, manslaughter. There are 2 kinds of manslaughter. UDA manslaughter, or what we call dangerous act. Okay. The other type of manslaughter is what we call negligent manslaughter. Just let me write this here. UD, unlawful and dangerous act. And finally, what we have is we've got defenses, which is what we're doing with 11. All right. So for exam purposes, what I suggest is after today's lesson, pretty much we start doing past papers already. You see something like this might be 20 marks. Obviously, it's not every year it's going to change, right? But I'm just giving you a general overview of how a typical exam might look like. So for example, you get one question on offenses against a person, you might get 1 sexual offense question, and you get 1 homicide question, which is my favorite question because the structure is always the same. It's always like this. Okay, and then we've got defenses, which is incorporated to all these 3. So you might see maybe for question 15 marks is for murder and manslaughter, and then the other one is 5 marks for defenses, for example. Okay, any questions so far on how you want to? Yeah, Will.
Just in terms of answering the question, so it says if it says I'll discuss someone's liability for homicide, the first thing we'll assess is murder and then manslaughter, and UDA and negligence. Is that
So first thing, yeah, murder, and then UDA, manslaughter, and then negligence by act and omission, 2 types. You're way ahead of many people. And then we have defenses, right? So UDA, we have the negligent manslaughter, 2 types. Furthermore, by act and omission. That's something I'm going to discuss later on in this class, but since it's been brought up by Will, what I'm going to do is just really quickly in the exam, for example, if you see that something is clearly not murder but homicide, do you still discuss murder? Yes. Okay. Just because you kind of want to go through why it's not murder, and if you don't do that, you automatically lose quite a fair bit of marks. So you can see that actually law exams are pretty easy. Probably I'm the only few people who say this, but anyway, law exams are pretty easy if you are able to get this big structure. That being said, which week are we in right now? Week 10. So law exams in like 3 weeks time, 4 weeks time maximum, and people who are doing high school note-taking style, I think it's a really good way to do it because just like high school, you will do practice papers, right? So now is the time to start doing practice papers. If you want to get your HD or your straight HDs, that's the best time to do it. Okay. As there are some of you who email me once in a while asking me for feedback and stuff. Like usual, I'm happy to review it. If you're happy to put the effort. Okay, so today, yeah, like if we look at the slides, UDA, start with UDA, and then we have manslaughter by criminal negligence, criminal act, and then by omission. And then we continue where we left off last week with the practice question 4 for the remaining 12 marks. And then obviously, if there are any questions, as per usual. Okay, so let's get started. Yes, that's a schedule in week 10. Okay, so let's start off with UDA. So the difference between manslaughter and murder, I guess, is very standard sense, is that manslaughter is a less severe one to murder. Okay, it's the foreshort of a murder. It's again defined in common law. The Crimes Act, just like murder, okay, sets out the punishment for manslaughter. The two types, unlawful act, okay, unlawful and dangerous act, UDA, and negligent manslaughter by act or omission. Okay, so kind of in the exam, you want to discuss all these three things. Now, let's start off with UDA. Okay, so again, these are the kind of elements. Now, I just want to say that sometimes you might see certain sort of variations, certain people put certain elements first, second. As long as you get the big structure, you will be on the right pathway. Okay, now, if we look at this as per Lamb and Campbell, the prosecutor must prove beyond reasonable doubt that D committed a base offense that was unlawful and objectively dangerous, which caused the death of V. Okay, so one of the most fundamental things for UDA manslaughter to be made out is that there must be a prima facie unlawful offense, a base offense, okay, such as battery or assault or whatever other base offense. If there is no base offense, there couldn't be UDA manslaughter. Okay, so if we break it down, first of all, there must be an unlawful act. Okay, if D simply did not do something that he's required to do, then that will be omission, then that would then fall under UDA manslaughter. Okay, the act must be objectively dangerous, so you want to see what exactly does objectively dangerous mean, and that's when you start to use your IRAC and you say, okay, what does objectively dangerous mean, and then you quote the law, and then you apply it. Okay, again, there must be a voluntary act. Sorry, I should put voluntary act instead. And then death of a human being, elements 3 and 4 not really contentious 90% 99% of the time. Element 5 is causation. Again, all the rules of causation we look at from last week applies here as well. Okay. MR is the same as the unlawful act. So first of all, we say, well, okay, what exactly is unlawful? First of all, the prosecutor must prove that it must be in breach of the criminal law. Okay, it could be an unlawful act, but it must be in breach of criminal law. For example, today, some of us, I just maybe I didn't pay an invoice of $1,000. Okay, that might be breach of contract law, but that's not unlawful act for the purposes of UDA manslaughter. Okay, but in comparison, if say, for example, I stole $1,000, that would be theft. Then that would be in breach of criminal law. Okay, so there must be so first of all, you must identify a foundational offense. A lot of people, including back then when I was doing criminal law 1, people just keep writing UDA and didn't write down this idea of identify the foundational offense. Okay, if they don't do that, they don't get the main idea. Okay, yeah, so that's the main thing. And then you have to, okay, one other thing is you kind of want to prove all its elements, including the requisite fault element as well. So this is when things start to get a bit interesting because in the exam, what you will be doing, let me see. You will be like element 1, unlawful act. Right? Okay. And then you obviously have your death of a human being, causation, blah, blah, blah. But also under this heading, oh goodness, why is the marker running out of everything? It's over there, okay. But also under this heading, for example, you identified battery as your foundational offense. Okay, you call Campbell and Fagan obviously. And then what you have to do is you sort of have to make out the elements of battery as well. 1, 2, 3, 4, blah, blah. So that's when you see things start to get a bit complicated. And sometimes if you're not familiar with this, you might repeat yourself. So when things start to repeat themselves, you want to say, okay, as above. Let's move on. Here are just some case law that help you define what is unlawful. Let me just take a look at this. Okay, so sometimes your examiners like to do this thing called like argument by analogy or argument with comparison to the facts. So in the case of Lamb, the boys playing Russian roulette were not apprehensive / no intention, so there was no assault for UDA. So if you see some people in the casino playing roulette or sort of this kind of things, and there was no apprehension, there was no UDA, there's no unlawful act in that case. Pointing a gun at victim's back was attempted assault. So even though there was no sort of no apprehension, but again, there was an attempt. In criminal law too, you will learn about attempt. And therefore, it was made out as well for unlawful act. And then there was the case of stay was when there was a consensual SAN. When V died, it was unlawful act, okay, because the law would not permit consent. Remember this case when we first started off, okay. So these are just some cases by analogy. The fundamental law doesn't change. So let's look at element 2 now. Objectively dangerous. The act must be objectively dangerous. So in the exam, you just have to simply quote this sentence. Would a reasonable person in the accused position performing the very act which the accused performed have realized that he was exposing another of an appreciable risk of serious injury? Okay, that is a test. And then what you simply have to do after that is you just have to make use of the facts and then analyze and say, okay, whether the act was objectively dangerous by reasonable fashion.
Would you prefer that we like just quote the direct judgment, or like can we paraphrase that then put in brackets? Still like for this case, but just paraphrase the.
Yes, either way works. Either way works, yeah. For me, it's just I prefer to just quote it because it's easier. Also it's a judgment, so it's fine to just quote that carefully. But yeah, if you want to paraphrase, not an issue at all. Let's move on. Okay, so element 3 is voluntary act. This is pretty much the same as everything that we looked at previously. Nothing much to talk about. Death of a human being again has been talked about before, last week's lesson. Only thing you need to look at is section 41 of the Human Tissues Act, but then the question will always tell you if the person has died. If not, they can't set a murder / homicide / manslaughter question. So 3 and 4 not contentious. Right. You see the way when I teach this class, the contentious one I spend time, the shouldn't say useless, the not so contentious one I just skip it. Same thing for exam, okay? Because again, when I tell you when I was in year 1, this friend, sorry, I keep using this friend, but this friend couldn't finish the exam because this friend spent like 50 minutes writing voluntary act for offenses against the person. So that's the reason. Okay, now causation again, this is important, but you will have discussed it very in-depth in murder, isn't it? When you're looking at the same question. So causation probably will not be that important if you already have referred to it in murder. But sometimes if the question is clearly a case leaning towards homicide and you simply just discuss causation very briefly in murder, that's when you have to discuss causation in depth in your manslaughter. Okay. So again, the rules of causation are the same. Because yeah, some things are very similar. Just have to remember act of nature, act of victim, act of third party. And then also consider medical treatment issues. This is sort of the way that I break it down, because there are too many rules available out there. So if you just make sure if you see certain things that are contentious, sort of do this checklist, and then you'll be fine. Okay, let's talk about MR. Oh, we're very fast. Now, MR, remember when we talk about UDA manslaughter, there must be the commission of a base offense. Okay. So the MR of UDA manslaughter depends on the establishment of MR of the foundation, fundamental offense. What does this mean? For example, the unlawful act is battery. What's the MR required for battery? Intention, recklessness, negligence, which of the two? Intention and recklessness, yeah. Okay, so yeah, that's when you just have to see whether the foundational offense, intention or recklessness has been made out. And then if that's made out, the MR for UDA manslaughter is made out. Easy? So that kind of helped you a bit with the MR aspect of UDA because you don't have to repeat yourself too much. Now let's talk about negligent manslaughter by act. Okay. So where are we right now? We're pretty much done with half the class today. Not really, 1/3 of the class. We are done with this. Okay. So we're looking at this right now. Negligent manslaughter by act or omission. This is a bit difficult actually, because when I studied this, I was like, oh my goodness, it's a bit confusing. But once you get the rule, and then you know how to apply, find the appropriate structure for this, and you'll be fine. There are too many structure for this, I think, personally from my memory. This is just one of the ways to do manslaughter by gross negligence. There are obviously other ways to do this as well. Find the one that's suitable for you. But I'm just going to share with you how I might want to approach a question like this. So first of all, you need to understand that there are two possible ways of manslaughter by gross negligence. So the broad category of criminal offense is first of all UDA, second of all gross negligence. And then under gross negligence, there are two subcategories by act and omission. From the diagram, you see sort of the things I wrote there. So then we look at what is the common law definition for gross negligence. Okay, there must be a great falling short of the standard of care that a reasonable person would have exercised involving such a high risk of death or grievous bodily harm would follow that the doing of the act merited criminal punishment. So you quote neither. Doesn't matter whether you're referring to act or omission. First of all, set out the general test, just like everything. For example, when you quote Fagan for battery or assault, you must say that must be intentionally or recklessly, okay, and perform a voluntary act that caused apprehension of immediate unlawful force, something along those lines. So you quote this as well. Okay, let's move on. This case, yes, this case of NIDM, I think is quite important for you to read the facts of NIDM, because sometimes your school, your examiners might get inspired by the facts of NIDM and create a problem question based on this as well. So yeah, that's just the test. So let's break down the elements. So the actus reus, first of all, is that D causes the death of a human being. So causation is an element, death is an element, human being is an element. It's the same for both by act and omission. First of all, these three. But do you really have to discuss these three? Sort of, you kind of have to discuss, but you already discussed it probably twice before this already. So not that important unless the facts are different. Obviously, if the facts are different, you want to discuss, but if it's already there, then you do it. So let me repeat again: causation, death, human being. Okay. Now, the next AR is that the act, okay, is either one of the following, either the top one or the bottom one, by an act that breaches a duty of care, or by omission, where there was a duty to act and this is breached. So you want to see situations where there was a duty of care and there was a breach of duty of care by act, or there was a duty of care to act, okay, and this is breach. Okay, I'll give some examples of both later. This is where case law are becoming really, really important. Who here has read the reading guide or the cases for this week? A long list, isn't it? Yeah, so that's when you have to really compare the cases and see, okay, which one fits in where. This really tests your understanding of cases. For sexual offenses, is that the case? Not really. Why? Because you just look at section 38, 40, 43, 45, looking at 30, 35, 36 for consent, and then looking at JDA. There's not much case law going on, isn't it? But this one is a crazy amount of case law. All right. Okay, before I move on, actually, let me just talk about one other thing. When we talk about the breach of duty by act, we just want to note the general presumption that we all have a general duty to not harm others. So sort of the general test apply. Because whether you look at the act, whether it's a great falling short of the standard of care, that reasonable person will not have done. Okay, so by act is sort of pretty much you state the law and then you argue by logic. Okay, but then for omission, there are quite a fair bit of rules. So that's why we talk about, yeah.
So I just had a question. So like, when it says general duty not to harm others, so like if I just give a hypothetical, like I'm seeing this, I have a general duty not to punch someone else in the face.
Yeah.
Is that, yeah.
Yeah, of course. You could try and see how your friend reacts to you. Alright. But omission is a little bit more interesting. Let me just give an analogy. Say, for example, that table, there's a lot of PowerPoints, isn't it? For example, one of the PowerPoints set on fire. Okay, and then maybe there was a fire extinguisher over here. Okay, but Shane was lazy. Shane says, I want to go home, I don't want to do this. And Shane just walked out of the class. Okay, and as a result, the whole class was set on fire. The rest of us passed away. Okay, and then that's where we could ask, okay, is there a duty of care to act or not really? Okay, then that's when. Okay, so that's when things start to get a little bit interesting. So I want to look at some of the rules that we have. So what are some of the common duties? These are also things that you want to take special care from your reading guide. First of all is when duties arising from the creation of a situation of danger. Okay, so for example, if the defendant creates a situation of danger and D may be the only person with knowledge to act, the duty arises. Let's change the scenario a little bit. For example, it seems that Shane is still writing on notebook. He obviously doesn't use any laptop. But what if he brings in like an external monitor and PC and everything and overloads that and charge that? He set the whole classroom on fire. That would be. Let's not look at him, guys. I'm sorry. Now, let's not look at him. So then he will probably have created a situation of danger. If he does so, then he will be under a positive duty to act. Okay. Whereas if you just simply use a notebook and you didn't create any situation of danger and you were just sitting there and you cared about your life and you decided to run the moment there was a fire, yeah, you don't have any duties. Make sense? Okay. Now, second one is the assumption of responsibility. So sometimes in all these three different cases, again, you need to start reading them. I can help you break down, but obviously you need to spend some time going through the cases yourself as well. If you voluntarily assumed a duty to act, that's when you need to also have certain sort of duty of care that is being owed. Okay, so I want you guys to read through this. I'll go through a little bit in a while, but the third category is relationship duty. One of the most common ones is parent-to-child duty of care. Okay, for example, if these two parents were on or going to gamble at a club, or whatsoever, playing the pokies machines, for example, and they left their kids in the car and the kids suffocated. Could the parents argue that, oh, it's not my fault, I didn't do anything, because it's just an omission. I didn't cause the death of my kid. No, because there was a positive duty to act in that case, and they have breached that duty. Things would be a little bit different, isn't it? If it's two adults over there, and one adult decided to just sit in the car and do nothing and suffocate to death, then there wouldn't be any duty to act. Okay, so let's look at the MR. So first of all, you have to remember, this might be a little bit confusing to understand. But let me just read this out first, actually. The question to ask is, was there a gross or great falling short of the standard of care a reasonable person would have exercised in the circumstances which involved such a high risk of grievous death or grievous bodily harm could result that the conduct deserves criminal punishment? Okay, or you want to rephrase this? This is a little bit complicated phrasing, I think. So, great falling short of the standard of care of a reasonable person. Okay. Now, you need to kind of imagine this. Okay, you have various levels. The top one is intention. Then you have recklessness and negligence. Intention is sort of 100% or 90% want to do this. Recklessness is I sort of foresaw the possibility, the probability of something happen. Negligence is, oh yeah, you just breached the duty of care that a reasonable person would have exercised in your circumstances. Okay, see the difference between the three? Okay. Now let's move on. The practice notes set out a sort of a structure that you could follow. So first of all, you could say that you could quote the Negligent test. Okay, so first of all, you must say that there is a breach of duty of care. Okay, if it is by act, you argue why was there a duty? There was a general duty not to harm others. Okay, that's the duty. If it's by omission, you're looking at the case of whether it's voluntary assumption of duty, whether it's a relationship duty, or whether a relationship duty, or whether there was a creation of danger duty. Okay, and then there is a gross departure of the standard of. There's a gross departure of the standard of care required by a reasonable person. So this is sort of the MR aspect. All right, and then finally the act merits criminal punishment. So you see, there's quite a fair bit of different ways to do this. One is obviously, you could do by elements again. You could say death, causation of a human being, and then by act, by omission, and then you do the MR. Okay, quote in item. Or you could just simply go back to this idea of this test over here. You could simply go back to this statement and just do a whole chunk of analysis. Okay, and then you break down the elements again. Okay, maybe not so clearly delineate the AR and MR in the sketch notes, but by doing so, you still cover the fundamental idea of what has been posted in mind. I mean, can you guys see the different approaches that we could do for negligence? You could you could go and find out your own structure as well. That's why I say you need to do practice questions. Because if you don't do practice questions, you don't know, holy shit, this takes 15 minutes to write this part of the question, for example, that's one. Or you go to your exam and say, okay, so I know the test, I know what's in item, I know what's in tech, I know what's that case, I know this case, but I don't know how to apply. That's why you need to start doing practice questions. Who has already started to do practice questions? No one.
I think everybody has.
I mean that too, or the midterm assessment. Yeah. What about sexual offenses and homicide? Anyone has started on that? Yeah, because everybody has, because you're forced to do it, isn't it? But if you want to become a little bit different, then you obviously have to start earlier. If not, everyone will get the same results, right? So you want to be different, that's what you have to do. So we are very good. Today we have a lot of time to discuss these questions. Okay. So we're going to spend the next 20 minutes discussing this question. Probably give you guys 10 minutes to walk through this one and think about the appropriate structure. And then in another remaining 10 minutes, we're going to go through and answer these questions. Okay, and then obviously for the three of you who came a bit later, I have some mooncakes over here. I'll walk around if you guys are more, feel free. Okay, so now this is the question. Oops. This is a question from last week actually. Just give you guys a reminder of what has already been discussed here. So this was the case about Harry and Sandy. Okay, Harry's criminal liability in relation to Sandy's death. Last week we sort of argued maybe there was the chain of causation that has been broken, maybe it hasn't been broken. Okay, so we discussed, we allocated about 8 marks out of these 20 marks to murder. And we say that we will continue with manslaughter. So I'm going to give you guys some time to discuss and find an appropriate structure for this. Oh.
That's not what the office said. I'm so worried about it. Wow.
Anyone type out the answer to this beforehand? Has anyone type out the full answer to this question? Oh, sorry, so not to move faster. But for example, show you as a thing, we got to go to see that you just say that or that.
On the videos, it's constructed. That's they mentioned it. But it's constructed. No, they mentioned and like the elements.
Policy,
Yeah. Oh, okay. Yeah. What's that one? Well, so it's I actually was one which battery. Yeah, that's all. What's wait, so the MR of the manslaughter is the basic. Yeah.
If you choose anything else.
Yeah. If you have the,
My suggestion.
for,
I don't know.
or,
Yeah, because I know what I do. I look up the answer structure. And then.
so these have to, doesn't have and Medicaid circumstances. It's or would be some.
How much?
So it's not about.
Very good factor. If you do practice question, someone's a guarantee.
So that also. I asked.
Everything.
I just make sure it's there at the camera when you get
What is it you do?
Yeah, like a password. And then you can look at it 10 years later.
Obviously, they are say they're strong. For example,
Full never ends, so full going. Oh, I'm sure it's sure. And where it's just you will. Yeah. It's 55. Never fucking move.
all right, let's discuss. 10 minutes has been passed. So, who wants to start off the floor? Sounds like we're doing model United Nations, isn't it? All right. Who wants to make their opening statement? You. Okay.
Oh, oh, I'm not actually okay.
Yeah, okay. Tell us how you will structure it. Come on.
Murder,
Murder.
EDA, manslaughter.
You did manslaughter.
Manslaughter by negligence.
Okay, manslaughter by negligence, and then negligence. So simple. You know, my favorite question is murder. Sorry, homicide questions, because it's the easiest 20 marks I could ever get in my life. Yeah, it's the easiest 20 marks because why? You know, when you go to offenses against the person or sexual offenses, you still have to think: is this rape? Is this sexual penetration? Is this by fraud? Is this what other nonsense? It's 45, 43, right? You still have to think about those. But for every homicide question, the structure is just always this. Okay, I'm going to get slapped on my face if it isn't this one, but at least for the past, like all the exams that I've seen, papers so far, this is obviously the allocation might be different. This might be like 10 marks because it was clear homicide question, and they give you like 3 marks, 4 marks on causation discussion. But the big structure is the same. Okay, obviously there's still defenses, but we haven't talked about this, so next week we'll talk about defenses. Okay, so out of 20 marks, maybe this might be 16 marks for this, maybe I give 4 marks for defenses. Okay. And then on this table over here, on the girls table, just now I talked to them about this idea of so I forgot what I think. Yeah, so there was murder, manslaughter, negligence, defenses. I talk about how you could prepare answering script, because sometimes you do have very thick notes from lectures, but you go to exams, you just bring that script. I think it really helps you. Just remind me, talk about exam technique after I discuss this answer. Actually, I do want to talk about that a little bit. Okay, so we talk about manslaughter. It requires the commission of a base offense as per Lamb and Campbell. So, what is the base offense over here? What did Harry do? He shot the gun at who? Sandy, okay. And what was the offense? So what was the offense? That's the action, isn't it? Yeah.
So if it's not section 18, is it just battery?
It could be battery, it could be, yeah, it could be section 18 as well, either way.
It said, it can't be section 18, because apparently the base offense can't be more than 10 years. So there was something for constructive murder. They said that, the base offense.
Yeah.
Is one which is punishable with up to 10 years or something. Something up to 10
They
years.
say, yeah, so, so it can't be section 18, you say? But 18 causing injury, isn't it? Causing injury is 10 years, I remember off my head. Don't have the legislation in front of me. Yeah, but go with what that slide say, but the idea is you have to identify the base offense. So battery will be a good one because battery has always been used in exams. Okay, and then if you do enough practice questions, you will see every sort of things where the examiners notes they tell you, okay, that requires the commission for base offense. The base offense is assault, the base offense is battery. These are the things I keep saying. See, sometimes I don't see section 18 off my head actually. Go and check that. Yeah, because 16 and 17 is intention causing serious injury, reckless causing serious injury. That will be higher. But I believe 18 shouldn't be that. Okay. So yeah, it requires the commission of a base offense. The base offense here will be battery. And then discuss the elements of battery, right? Firing the shot at Sandy's leg. There was an MR as well. The MR is probably intention because he doesn't want Sandy to come near his property. And then you talk about causation, you talk about death of human being, and manslaughter is done. Any questions on manslaughter? No? Okay. What do we do next for negligence? Is this a case by act or by omission? So who says by act? Who says by omission? Who says both? Whoa! You need to discuss both in your exam. All right. So this is when first of all you say, well, okay, you call the big test in item. There was a great falling short, gross falling short of standard of care. Okay, there was a appreciable risk of serious injury in those circumstances that a reasonable person would not have taken those precautions. Okay. And then you say, okay, what is the act? The act sort of is a similar thing, right? By you firing a shot and maybe you were negligent, I might dismiss the argument and still say it's UDA, but you could still bring out the fact that shooting at Sandy's leg could constitute negligence as well. So that's sort of the act. The act is the same thing. But what's the omission? Not helping. Why must he help? Yeah, he created a situation of danger. And then you just have to discuss, okay, so a question.
So for the negligent, if you argue that there's no degree of care between Harry and Sam, so it's not.
You want to argue there was no duty of care, right?
Yeah, but both the omission.
With the act, there was no duty of care. But isn't that's a general duty to not harm others?
Oh, yeah.
Yeah, so sometimes, for example, just now in your question, when I was discussing the table, we talk about manufacturer's liability and the omission to do things. That's where there are rooms for discussions, where as long as you state the law, you go both ways, that will be fine. But in this one, the answers are pretty straightforward. Go.
I know one of my classmates, when they talk about negligence, they use Donohue's.
That's a sports.
principle that wouldn't apply to students. Is that the case?
Donahue and Stevenson, isn't that the ginger beer case
Yeah.
where they talk about you talk about manufacturer's liability, that's what you get in tort law when you talk about duty of care.
So for maybe this would apply in this case. I mean, just in general, not in this circumstance, but you wouldn't use the.
Did you, I don't think I read through Donoghue, as in I read through Donoghue Stevenson in high school, and I read through that a lot of times, but as in I read that a lot in tort law, because you're looking at that in tort law and how duty of care in civil cases. But I thought I read that in your criminal law slides, isn't it? If it's not something that's been brought up in your Moodle, just don't use it. Yeah, okay. So that's with the negligence, and then you just go through the elements of the negligence, whatever structure that you prefer. Question?
Is there an authority for like having a duty not to harm others? Like, do we just refer to any authorities, or can we just state it?
From my memory and from my slides that I could remember, there's a general duty. Has there been something that's been different on your slides or? No? Yeah, if not, that's the case, then just say the general duty. Also, so how I structure my notes and stuff is I get a lot of my inspirations from past examiners report. So a lot of my quotations were taken from past examiners reports. That's why you could do that. Okay, so let's talk about the answer key. So first of all, what I will do, unlawful and dangerous act and negligent manslaughter. So 8 marks for this section. First of all, unlawful act. The base offense is battery via dog, vegan, and then causing injury / serious injury. AR plus M are required nonetheless. The fact that I wrote injury / serious injury, I took this clearly from a past exam paper. It's not a past exam paper, I clearly took the answering structure from past exam paper. So it might be that injury or serious injury could be acceptable, but I will check that regarding the 10-year point. And then we have dangerous, okay, it's the act involving an appreciable risk of serious injury. And then we quote NIDM, okay, great falling short of standard of care, breach of duty, okay, conduct below the standard of reasonable person, that merits criminal punishment. So that's when the 8 marks go to. And then remaining 4 marks goes to self-defense. Maybe he thinks that the police came to him and want to kill him or whatever, which doesn't really make too much sense. But you still have to discuss whether self-defense applies in that case. Since I'm just going to give me 2 minutes really quickly talk about exam techniques. What I will do in exams is I might bring, so for myself, okay, I'll bring paper legislation. What I will print out, first of all, I will print out the Crimes Act. So offenses against the person, you might want to look at 15 to 24. That's about 8 pages long, I believe. I will print out the Crimes Act section 35 to 45. Okay, specifically, why is this important? Because I will be looking at 38 for rape, 40 for assault, 40 for, what is it, sexual assault, yeah, 43, 45. And then I'm looking at 35, 36 of definitions. And then I will be looking at section 3 to 9 for common law offenses, so for murder and homicide. But honestly, 3 to 9 is not that useful, to be honest. And then obviously, once you go down to defenses, you'll be looking at section 322. That's when it's also quite important as well. These are the things I will print it out, and then I'll have it in front. So that's one I will do. The second thing I will do is I will have my answering script ready with you. But when I say script, it's not really 100% script, but more of you put your notes in a way that is suitable for exam format. And then you do practice questions. You do this a few times. Ideally 1 practice question a week, and then you'll be able to get your HD. And then write me an email, tell me you get 90 for crypto. All right, I will see you guys next week for defenses. Bye-bye.